It's really our pleasure as a school to have Mr. Gordon Cooney with us today because of the wonderful work he has done, which you're going to hear about in just a few moments. But in the way of introduction, let me indicate that he's a member of the class of 77 here at Episcopal. He went on to Wesleyan University, and he's a lacrosse person, played there, and then went on to Villanova Law School where he received his degree. He's a partner at Morgan, Lewis & Bockius. And let's see, he just argued a case, and that was in early October before the Supreme Court, and did a wonderful job with that, and he will be talking with you about some of that as well. After the seminar, it'll be just during chapel time. Anybody that's free can stay because we're going to continue a discussion that relates to legal ethics. My A-block ethics, which is in the back, some of you, remain in chapel, and we're going to continue on with Gordon. What he's going to be telling you about is really something that was written about in an incredible book called Killing Time, which documents the particular case that he's going to present to you. And I want to read just a short snippet to you that really, I think, is descriptive of Mr. Cooney and the valuable work that he does. It was the first page of chapter 26, and it's done in a diary form, July 25th, 1995. John, referring to the person who was imprisoned, had never seen any lawyers do things like that. Watching Gordon, our speaker today, get angry with Connick's men, explaining things to the judge, watching him cross-examine Funk. That was what John had always believed lawyers were supposed to do, to be there, to help people who couldn't help themselves in the system. No one's done it better than our speaker today. Please stand to greet Mr. Gordon Cooney.
Thank you, Jim, and it's absolutely great to be here at Episcopal with all of you today, and thank you for your time. I gave a lot of thought to how I wanted to start this discussion today, and I thought the right thing to do was to start with this. This is a picture of my client, John Thompson. It was taken in 1985 when he was or 1983 when he was 20 years old. And the reason why I wanted to start with this is because there's a tendency sometimes, and particularly for lawyers, to think that they're handling a case or they're handling a cause, and to forget about, in the last analysis, it's about people. And this, in the last analysis, was about John Thompson, our client. In 1983, when this picture was taken, as I said, he was 20 years old. He was a young man in New Orleans. He had dropped out of school early in high school. He had two sons, and the person that you see there is his young son, John Jr., who was about 18 months old when this picture was taken. And the reason why I wanted to start with this is because in the last analysis, it's about people. In this case, it's about John Thompson. I want to give you a little bit of the chronology, because there were actually two crimes for which John Thompson was charged, and it's important to understand the chronology, and I have it up here. On December 6, 1984, there was a killing of a man by the name of Ray Liuzza Jr. Ray Liuzza Jr. was the son of a very prominent New Orleans hotel executive. Mr. Liuzza was in his early 30s and was a successful businessman in his own right. And he was leaving his car outside his apartment in New Orleans at about 1 o'clock in the morning. He had parked his car across the street from his apartment. He walked across to his apartment, and as he was walking across the street, he was robbed, shot, and killed. Terrible event. It set off a huge hue and cry about public safety in New Orleans, and there was an incredible amount of pressure on the police and the district attorney's office to apprehend the suspect. 3 weeks later, there was a completely unrelated carjacking. 3 children, the Lagarde children, the older brother who was 19 and a freshman at the University of Virginia, and his 2 younger siblings were coming out of a basketball game at the Superdome, and they were carjacked by a young African-American male. The carjacker told the older brother to drive off, and while they were driving off, he was instructed to provide the carjacker with their wallets and watches and so forth. And in an incredibly heroic move, the brother intentionally crashed the car, leapt across the front seat into the back seat where the armed perpetrator was there, struggled with this guy, kneed him in the face, the gun dropped, perpetrator fled, and there were no suspects. 3 weeks after that, John and another man by the name of Kevin Freeman, so now we're talking the middle of January 1985, John and Kevin Freeman were arrested for the Liuza murder based on an informant's tip. John's picture appeared the next day on the front page of the New Orleans newspaper, and the father of the 3 Lagarde children sees picture of scary-looking murder suspect on the front page of the newspaper and says to his kids, "Is this the guy that carjacked you?" The children say, "That looks like the guy," and they call the district attorney's office. Now, this was a big break for the district attorney's office because our client, John, had no prior felony convictions. He had never even been arrested for any kind of crime involving violence. And if the district attorney's office could charge John with another crime and get a conviction on it, that could be used by the district attorney's office in the murder case. So based on this eyewitness identification of the 3 children, John Thompson was charged with the Lagarde carjacking as well as the Liuza murder. The district attorney switched the order of the trials, completely lawful under Louisiana law, and they tried the carjacking case first. The lawyers who represent Mr. Thompson, John at the time, asked whether there was any scientific evidence, blood evidence, the kind of stuff that you hear about in CSI. The lawyers were told no, there's no tangible scientific evidence or anything like that. They went to trial, and based exclusively on the identification by the 3 children, John was convicted of the Lagarde carjacking, and he was sentenced to 49.5 years in prison without the possibility of parole. That did 2 things in the Liuza murder case. It meant that if John took the stand to testify in his own defense in the murder case, the fact of the Lagarde carjacking could come into evidence before the jury in the murder case. The second thing that it did is murder cases are divided into 2 phases. The first phase is the so-called guilt phase, where the jury decides whether the defendant is guilty or not guilty. And then if the defendant is found guilty, there's a second so-called capital phase, where the jury is asked whether the defendant should be sentenced to death or receive life imprisonment. And what it meant was, in the capital phase, regardless of whether John took the stand, the facts and circumstances of a Lagarde carjacking could come into evidence. So the Lagarde carjacking was a very significant part of the murder case. I want to step in front of the podium for a second and work and show you a little bit. I'm going to show you a diagram of the evidence against John at trial. Thank you, Jim. Thank you, Jim. And I'll try to walk around a little bit because I know you can't see all of these. But if you look at this chart here, this is a diagram of the crime scene. And what you should be able to see, let me see if I get this pointer to work, I'll walk around a little bit, is the evidence against John was primarily from this guy, Kevin Freeman. Remember I mentioned Kevin Freeman was charged along with John with the Liuza murder. After John and Freeman were arrested, Freeman immediately told the police the following story, which he then recounted to the jury at trial. He said, "I was driving along in my car, and I ran out of gas down here in the lower part of this diagram." So if you see, it may be tough in the back, but there's a green box, if you will, that represents the car. He said, "We ran out of gas, and I parked here at the bottom. We started walking this way up sort of in the north-south or south to north direction on this map, when, according to Freeman, John said, "I'm going to go hit the white dude." Freeman said, "Mercy, I will have nothing to do with this." And he claimed that he ran home, took his bath, went to bed, and came back the next day with $2 to put gas in his car and take his car home. He said that while he was running off, he heard John Thompson struggle with Mr. Liuzza, shoot him, and kill him. He said he had nothing to do with the crime other than that. So that was pretty powerful evidence against John. Compounding that, a ring that had belonged to Mr. Liuzza and a gun that was probably the murder weapon was traced to John. Unfortunately, remember, John couldn't testify in his own defense in the murder case because of this carjacking conviction. Unfortunately, John, at the time, back in 1985, what he did after he had dropped out of school was he bought and sold stolen property. And he had bought and sold the ring and the gun. And guess who he bought it and sold it from? Kevin Freeman. So he had bought the gun and the ring from Kevin Freeman, but he was unable to explain to the jury that fact because if he had, the jury would have found out about the carjacking. So that was the evidence against John Thompson. There was Freeman's testimony going back to this set of events, and there was the fact that the gun and the ring were traced to John Thompson. It sounded like pretty powerful evidence to the jury, and not surprisingly, the jury convicted John Thompson of the Liuzza murder. And then in the penalty phase of the case, the Lagarde children testified tearfully before the jury that if the older brother, Jay Lagarde, hadn't been a hero, there would have been 3 more dead people, and John Thompson was the carjacker, and based on that, the jury decided to sentence John Thompson to death. So pretty powerful evidence against John back in 1985. The evidence, however, was not only powerful. I want to show you a picture, and the saying is a picture says 1,000 words, and I think this picture is pretty telling. He was dealing with some very, very zealous and ferocious prosecutors that were really out to get John. What I'm going to show you right now is a trophy. It's about a 12-inch high toy electric chair, battery operated. You put a battery in it, push a button, it gives you a little shock. And this toy was sitting on the desk of one of the lead prosecutors in the case. What you see in the toy electric chair is a pasted body, and then on the top of the body are 6 heads. Those are the 6 heads, the faces, of the 6 men that this prosecutor had convicted and sentenced to death. Right there in the middle, that big picture in the middle, is John Thompson. Now, interestingly, as we sit here today, every one of those convictions has been overturned, and 4 of them have been overturned because of some form of prosecutorial misconduct on the part of this prosecutor. So I think this picture tells a lot about what this prosecutor thought. This was a game for him. This was a game where it was appropriate to have a trophy on his desk of the electric chair and with the heads of the various people whose lives were in his hands.